You're unconscious. Tubes in your throat. Your family's in the hallway. They're arguing over what to do next. My name is JP Rankin, and I'm an estate planning attorney licensed in South Carolina, North Carolina, and in California. I've helped hundreds of families avoid probate, create an estate plan, and a legacy that they know will work when they need it to. In this video, I'm going to explain exactly what a living will is, how it works, and why it's one of the most important documents in your entire estate plan. So let's get into it. What is a living will? Let me be clear. A living will is not the same as your last will and testament. A last will and testament is who gets your stuff when you die. A living will, they're your instructions when you can't speak for yourself and you're still alive, like you're in a coma or a vegetative state. Common scenarios where your living will is going to speak on your behalf. You're in an irreversible coma, terminal condition that's diagnosed by two independent physicians. Permanent vegetative state or permanent unconsciousness. Those are scenarios that arise and your living will speak for you. You choose whether you want life-sustaining treatment like artificial respiration, tube feeding, IV hydration, dialysis. Those are some pretty heavy things, and you want to decide whether you want those before you get into that permanent unconscious state. So why do you need one? Here's why it matters. You take the burden off your family. Without this document, that family that was arguing in the hallway, they have to guess what you would have wanted, or even worse, fight about it. A living will equals legal clarity. Number two, hospitals and doctors follow it. It becomes a part of your medical chart. They're protected from liability when following your instructions. North Carolina and South Carolina laws specifically authorize your doctors to comply with your choices. And furthermore, that document supersedes any other document in these scenarios. It's a very serious thing, it's very important, and it does exactly what you want, despite what your family may have been told by you a couple weeks ago. So be very careful when you're making the choices, because although they're incredibly important, they're also ironclad, and there is no time to wait. Once you have a living will, whatever it says there, once you're in one of those states that I said earlier, the doctor does exactly what you say immediately. There is no holding because grandma's flying in from New Jersey. None of that. It speaks for you and it happens immediately. So really important. Also, you have to be careful on what you choose. Number three, it prevents costly legal disputes. I know this might sound crazy, but in some cases, families do go to court and they fight over whether or not to keep life support. So a valid living will can prevent emergency guardianship hearings or ethics panels at hospitals. Those things are costly and they're going to drag out an already unfortunate scenario. So a living will gets you out of that bad scenario. The difference between a healthcare power of attorney and a living will, you make your decisions in writing, only applies at the end of life scenarios, and you leave clear instructions for the doctors. Nobody else is involved. It's literally a document between you and who is going to handle your life-sustaining or life-ending treatment when you get into those specific scenarios. Nobody else is involved. Healthcare power of attorney, different. You give someone or name someone the right to make decisions if you're unable to, so you're unconscious or any of those situations. If you didn't have a living will, you can simply have a healthcare power of attorney, and it can apply in a number of medical situations, not just the terminal ones. Best practice, have both. I like to have a healthcare power of attorney where that attorney has discretion to make decisions in very specific scenarios that do not overlap with the living will. And then you have a living will separate from the healthcare power of attorney that says exactly what you want in those terminal situations. Anything else, let your healthcare power of attorney, who you've nominated, you trust, and they know exactly what you want, make decisions when you can't speak for yourself. There are some requirements for a living will. It's got to be notarized and witnessed by two disinterested witnesses, which means a person who cannot benefit if you were to die prematurely. So if your children are set to inherit hundreds of thousands of dollars, they can't be a witness on your living will or your healthcare power of attorney. They can be registered with the North Carolina Secretary of State, but honestly, I don't recommend that because it doesn't need to be public knowledge. However, I always tell my clients, either North Carolina, South Carolina, or even California, when you fill these things out, make sure that whatever terminal you use to speak with your doctor, whether it's my chart or whatever it is, make sure there's a copy of that in there and they can access it quickly, because the last thing you want is to be on your deathbed and then have your son say, oh my gosh, I know mom has a healthcare power of attorney. It's in the safe and I don't remember a combination. And then they struggle to get it. And then they race down to the hospital and they, I got the and then something bad has already happened. Make sure it's on file. That way the doctor can access it quickly. And I always say give it to the person that you've nominated as your healthcare power of attorney so that they know where it is as well. Digital copies, we provide digital copies for all of our documents here so that you can send it to whomever you want, and especially to your medical healthcare provider. The benefit of living in South Carolina or in North Carolina is you're close to each other, and a lot of people go back and forth. So both states will recognize each other's healthcare power of attorney. So if you live in South Carolina but go to a hospital in North Carolina, good news, they will recognize it, but it makes it difficult because there is some different language. So what we always recommend to our clients is if you move to a different state and you are domiciled there, that's a fancy legal term, with the intent to remain, we always recommend updating it to that state in which you are currently domiciled. People come and go out of your life, your wishes change, so we also recommend updating those documents every 3 years. You may never need your living will, but if you do, it will be the most important paper you ever signed. If you're in North Carolina or in South Carolina and you want to make sure your family isn't left guessing or fighting about what your wishes are, schedule a free consultation. We'll review your documents or help you create an advanced directive package the right way.